Today, we have assembled to understand the principles of evidence. Now, please understand that though the Indian Evidence Act was promulgated in the year 1872 by Sir Stevens, but prior to that, there were other drafts submitted but not approved of. Now, this draft by Sir Stevens, when presented in the year 1972, in September, it was adopted. And think of the extraordinary draftsmanship that since 1872 a law is made and is applicable even today. As compared to this law, in independent India, we have written so many new laws, and those very laws collapsed. They could not pass the test of time. For example, we made TADA, it collapsed. We made POTA, it collapsed. But the laws made more than 100 years ago and the theories propounded therein are time-tested and are applicable even today. So let's see the wonder of this legislation. Because our legal system as on today is based on the principles of adversary system. In ancient times in India, the system which was prevalent was that if there is a litigation, there used to be the application of Nyaya Sanhita, which is part of our ancient scriptures even as in today. And according to Nyaya Sanhita, the search was to find the truth. But in adversary system, the system prevails that if a person lodges a complaint or files a suit, he has to prove his complaint prima facie. And the other side has to disprove. And the premise of law is that every accused is innocent till proved guilty. So the method of proving, disproving, not proving is the subject matter of Indian Evidence Act. So today we'll see how it operates, right? So let us first begin with the word evidence. As defined under section 3 of the Indian Evidence Act, evidence means all statements and all documents, right, which are presented before the court in support of the case. All statements are called oral evidence, and all documents, we all know, are called documentary evidence. But the definition of the word document as defined under Indian Evidence Act is much wider than the understanding of the word document in the common parlance. In common parlance, we understand the word document means anything written on a piece of paper. That is the basic understanding in the common parlance of a document. But the word document defined under Indian Evidence Act is far wider. It says any matter inscribed or prescribed on any substance through letters or by marks is document. Now, this wider definition also falls short of certain areas which under Indian Evidence Act we produce as document in the court, but they fall short of this definition. Actually, there's so many things which do not pass the test as document, but because there is nothing else defined in the Indian Evidence Act beyond oral statements and the document as an evidence. For example, if there is a crime committed of some scuffle, some hitting, some beating, hurt, grievous hurt, murder, and in this crime there must be some weapon used, isn't it? Now, during investigation, this weapon is captured by police, and while proving the case, that weapon has to be produced before the court. But unfortunately, in which category do you produce it? Neither it falls on the category of statement, nor it falls in the category of the document. So in my opinion, despite this wider connotation of the word evidence given under Section 3 of the Indian Evidence Act, still it falls short, because this third category is nowhere defined under Indian Evidence Act. So what we do, we produce these things as article initially till they are proved, and once they are proved, they are given exhibits. Like, for example, keep aside weapon. If a person is subjected to grievous hurt, or if a person met an accident, or if a person is killed, his blood-stained clothes are to be produced in the court. Under which category will you put it? Because as an evidence they are must to be produced before the court. And either they fall in the category of document and obviously not a statement. Now, despite this deficiency, what we do is we put all these items under the category of document. So to understand, evidence includes oral statement of witnesses of any incident, or in civil cases, in support of the plaintiff or defendant, and the document, which includes these weapons, blood-stained clothes, or any item. Now, the another aspect to understand is that what do we have to present before the court? So in a trial, something is called a fact. And what is the meaning of fact? What is the definition of fact? So fact is also defined under Indian Evidence Act. Anything, state of thing, or relation of thing. Anything, state of thing, or relation of thing is a fact. Now, the trial is conducted on a fact, either a criminal trial or a civil trial. Now, mind you, Indian Evidence Act applies on both civil as well as criminal. So, fact is both civil and criminal. But then, for a trial, this fact has to be refined. So, the fact has been refined by a qualification called fact in issue. Fact in issue means the subject matter of that trial. Fact in issue. Now, fact in issue is also defined as any fact, the existence, non-existence, nature, and extent. Any fact, the existence, non-existence, nature, and extent of any right, liability, or disability, any right, liability, or disability is asserted or denied. That is fact in issue. Now the Evidence Act further says that this fact in issue does not suffice. Fact in issue means the subject matter of the trial, but that is not enough. For example, suppose there is a fact in issue that A is accused of killing B. So there is a killing. The allegation of killing B, the deceased, is on A. So now the trial has to be conducted on the fact and issue of a killing. But this fact and issue alone cannot be the subject matter of the trial, because to prove as to why B killed A or how B killed A, A killed B. Now these questions require certain surrounding facts to be taken into consideration. Surrounding facts from the fact of issue. Fact of issue is the fulcrum.